The future of our great nation lies with our youth. We need the next generation of leaders and innovators to possess the skills and knowledge capable of advancing our country, something provided by our adept education systems. Our schools, in and of themselves, are individual communities, a place where students and faculty alike spend a large portion of their everyday lives. This community, if it is to be successful, must be founded on the grounds of equity and fairness, a reflection of our own country's legislation. The basis for equal protection has been debated for more than a century, originating from cases such as Plessy versus Ferguson. And the equal protection jurisprudence is an ongoing exercise in constitutional application, with the recent investigation on Harvard's affirmative action policies. Why is equal protection so pivotal to education? Why is it so commonly debated? And most of all, what does it mean to students?
The origin of the Equal Protection Clause can be traced back to 1866, when Andrew Jackson vetoed the Civil Rights Act. In response, Congress drafted the 14th Amendment. The 14th Amendment defines citizenship, while the Equal Protection Clause provides all citizens the equal protection of the laws, or equal treatment among those with similar circumstances. The Equal Protection Clause, as it relates to education, has evolved in both meaning and impact since its conception, impacting issues from racial segregation to opportunities for female students. Laying the groundwork for Brown v. Board of Education and school desegregation, the case Mendez v. Westminster involved a segregated school for Mexican children in Orange County, California. There, the federal district court declared that all children should be offered the same educational opportunity regardless of lineage. In 1896, in the case Plessy v. Ferguson, the constitutionality of separate but equal facilities was upheld. But the ruling was overturned in 1954, Brown v. Board of Education, where separate was deemed inherently unequal. The Civil Rights Act of 1964 applied anti-discrimination to work environments and public places. In 1974, Law v. Nicholas, the Supreme Court ruled that the absence of non-English learning tools in public schools was discriminatory under the Civil Rights Act. Andrew F. v. Douglas County School District 2017, it was decided public schools must provide a unique and appropriate education to special needs students. Title IX of federal civil rights law was passed as part of the Education Amendments of 1972, prohibiting discrimination on the basis of sex. Effects of Title IX at the school level are seen in female sport participation as well as transgender rights. The Obama administration clarified that Title IX's protections apply to transgendered students. All of these cases and legislation establish or clarify an aspect of equal protection in education, the treatment of students in similar circumstances, which is one of the key purposes of equal protection. However, what if the individual, in this case students, is unable to be treated the same as another? The educational environment is crucial to a student's learning experience and should maintain a certain level of quality, but many schools have a higher quality than others. A major contribution to a school's success is its funding, as funding affects everything from materials to food provisions, the extracurricular, and the effort put in by the staff members, as well as much, much more. Schools receive a majority of their funding from local governments from a pool of money, which mostly derives from property tax. A tax one pays depending on different aspects of their owned land. The larger the land or better condition of the land, the more one has to pay. So a poorer area doesn't have to pay as much as a higher end area. In turn, a school surrounded by a poor area receives less funding, and a school surrounded by a wealthier area receives more funding. This system costs some schools alternative funding, such as the provisions provided by the No Child Left Behind and IDEA programs, of which are typically authorized by wealthier schools. Affirmative action, first introduced by President John F. Kennedy in 1964, sought to enable minority classes that had been discriminated against historically. The remedy for previous maltreatments was favorable discrimination, the thread linking all affirmative action policies. This is visible in cases such as the Regents of University of California versus Bake, 1978, in which the University of California's affirmative action policies were allowed as favorable discrimination. Similarly, in the cases Gratz versus Bollinger and Grutter versus Bollinger, 2003, the court ruled that the University of Michigan's affirmative action system must only have a compelling interest in race, and established that affirmative action did not meet the criteria for harsh scrutiny. A quibble most may have with affirmative action is that it is a one-size-fits-all solution. Asian Americans, despite being a discriminable minority, are often discriminated against in many affirmative action admission programs. This is one of the most well-versed problems many have with affirmative action. For example, a well-off African American will get bonuses from college admissions due to affirmative action, while a struggling Asian American will be prejudiced against when applying for colleges. Harvard has recently come under fire due to their affirmative action policies, with a group of Asian American students receiving a lawsuit against such policies. Equal protection is the foundation for an equal chance, yet equality as a whole has not been achieved. That does not mean we should discontinue any pursuits for equality among our education systems. So, where do you stand? Should school funding be distributed equally among all schools locally, nationally? Should affirmative action remain unchanged, or should there be any reform? What other changes can and should be made to our schooling system? And how can we promote equality among our students?